Let me just kick things off by thanking you, Nitin, as well as Christopher and the team. It's great to be with the Xoogler community. Some quick introductions. I'm Joshua Sostrin. For nearly 3 years, I worked at YouTube, where I supported executive communications for the platform's chief product officer and chief business officer. After leaving Google a year ago, I launched Imperative Content, an executive communications consultancy that helps leaders strategize their messaging and content so that they can better tell their stories across various platforms and channels, from speeches and presentations to social media and op-eds. In addition to high tech, I also have communications experience in national security, academia, law, and politics. I've served as a speechwriter for members of the US House and Senate. Early in my career, I worked in film and TV development at Warner Brothers for the production company that brought the world films such as Ocean's 11, The Karate Kid, and the TV series Westworld. I also did some freelance writing for many years for comedian Jay Leno. And occasionally, I also help our guest today, my wife, Rita Sostrin, a little bit more about her. She's the founding partner of Sostrin Immigration Lawyers, a leading employment-based immigration law firm that U.S. News and World Report has named one of the nation's best law firms for 10 straight years. Rita has served in various leadership positions on behalf of the American Immigration Lawyers Association and is regarded as one of the leading experts in immigration law matters for individuals of extraordinary abilities. She is routinely approached by leading tech, academic, medical, arts, and entertainment companies for representation and counsel, and has established a very impressive record for winning complex cases in immigration law. Among many publications that list top attorneys based on peer review, Rita is included in the International Who's Who of Corporate Immigration Lawyers as a thought leader, Chambers USA, and the Best Lawyers in America. And recently, she was elected a member of the prestigious group IMLAW, which consists of 25 of the United States' leading immigration lawyers who work together to consult on emerging issues in immigration law to offer cutting-edge counsel to their clients. And needless to say, Rita's worked with many Googlers and Xooglers throughout her career. Before we jump into visa strategies for tech professionals, we just wanted to talk very briefly about two pieces of news that emerged in the last few weeks. Last week, it was reported that Apple must pay up to $25 million under an agreement with the Justice Department. Why? To settle charges that Apple engaged in hiring and recruitment discrimination while recruiting for roles through the government's Permanent Labor Certification Program, better known as PERM. PERM lets employers sponsor foreign national workers for lawful permanent residence status if they meet certain requirements, which leads me to this question, Rita. How does PERM work? And what is this fine against Apple really all about?
Yeah, so this is not that uncommon. We've seen a very similar Department of Justice investigation against Facebook or Meta today, as it's called today. They also similarly have to pay a fine. So I think those of you who've been through or who've maybe started the green card process with a prior employer, or you might be familiar with PERM, it's a standard process that employers utilize to qualify foreign nationals for permanent residence. Usually very common in the tech community. Certainly Google has utilized that process for its international employees as well. So the process requires the employer to conduct what we call a test of the labor market, or basically conduct recruitment and show to the U.S. government, to the Department of Labor, that they couldn't find what we call a minimally qualified worker for the job. So so they're not recruiting for the person's job, for your job. They're conducting a test of the labor market to demonstrate that they couldn't find somebody. And in Apple's case, and in Facebook's situation a couple of years ago, basically the Department of Justice found that they did that insufficiently. They had some technical violations. Like in Apple's situation, one of the issues that they found with their recruitment strategy is that they did not recruit on their website, for example, and they normally do recruit on their website, or they requested that applicants mail in their applications by mail as opposed to electronic mail. So these are very technical things. Apple is required to pay $25 million, which sounds like a lot of money, but obviously for Apple, not a lot of money. I don't think it's going to change anything in terms of Apple's ability to qualify their international employees for PERM or for other companies to be able to do that.
So let me ask you this, maybe Apple doesn't have to worry about this, but do you think it would put a little bit of a chill on employers, especially those at smaller companies and startups?
Well, something like this is always up to the employer. I always tell my clients, the employer is always in the driver's seat. They can choose to sponsor, they can choose not to sponsor, they can choose to sponsor after a certain period of employment. This is always up to the employer what to do and when to do it. But the PERM program is very, very commonly utilized by many, many US employers. There's really, especially in the high-tech world, there's really, that's the most common way to qualify somebody for a green card. They're simply not going to be able to get the talent if they refuse to sponsor people for PERM. That's just extremely uncommon for a company to have a policy that they won't use PERM.
Okay. Let's move on to the second piece of news. 2 weeks ago, President Biden issued an executive order on, quote, safe, secure, and trustworthy artificial intelligence. We all know that artificial intelligence is one of the hottest areas in tech at the moment. It's drawing a lot of investment. It's rapidly advancing, a lot of dramatic innovations across many fields that will impact our lives in many ways. The White House billed it as the most sweeping actions ever taken to protect Americans from the potential risks of AI systems. And among many things, the order requires new standards for AI safety, security, privacy protections for Americans, consumer protections. But I think what a lot of observers sort of overlooked was this one section that called for efforts to promote innovation and competition, including, quote, the use of existing authorities to expand the ability of highly skilled immigrants and non-immigrants with expertise in critical areas to study, stay, and work in the United States by modernizing and streamlining visa criteria, interviews, and reviews. Rita, what does this last aspect that I discussed of the executive order mean in practical terms for tech workers seeking a visa in the AI space?
So this executive order is kind of a big deal, and it just came out a couple of weeks ago. I've heard that it's the longest or one of the longest executive orders that there has been. So it is indeed many pages, which is kind of unusual, and it does contain a specific section on immigration, which I found really promising and interesting. So as you said, Josh, the executive order does talk about expediting visas. They really want to focus on bringing in AI professionals and STEM professionals. And it has very specific things that the order instructs the government agencies to do. I haven't seen that before, so that's quite interesting. There are specific timelines that the president places on the agencies, that the Department of Homeland Security within a certain period of time has to initiate certain policies. The Department of State has to do the same thing. Some of the more interesting things, well, one that I found unique, and that could apply potentially to everybody here, if you are for national working in the US or who plans to work in the US and maybe remain for a longer period, the executive order directs the government to review its Schedule A occupation. So Schedule A is something that's been developed by the Department of Labor, and it's a list of shortage occupations. So it includes nurses, for example, and I think occupational therapists, some other occupations that are considered to be in short supply in the United States. And these individuals who work in these occupations have a streamlined way to qualify for permanent residence. It allows us to avoid that PERM process that we just talked about with Apple that requires recruitment and things like that. So the shortage is presumed. So I think what the executive order kind of plans for the government to do is to include STEM and AI professionals on this list of shortage occupations, which is something really novel, and that would allow a whole new pathway for tech professionals and STEM professionals to qualify for permanent residence. So I find that really interesting. The other thing about just generally focusing on STEM and AI, this is not the only thing that the government has come out with, the White House specifically. About a year ago, no, maybe even more than a year ago, sometime in 2022, the White House, the Department of Homeland Security, which is what oversees the immigration agency, and the Department of State, which is the department that oversees visa issuance abroad, all came out with various policies about prioritizing STEM professionals, international professionals in the US. And they talked about that we should make it more streamlined for people to qualify for O1 visas, extraordinary ability, for EB1, which is a green card of extraordinary ability, and for national interest waivers, which is a green card based on work in the national interest. So they're saying that STEM professionals, that field is in the national interest, and that should be prioritized. So this is really, in the last kind of year and a half or so, there's been a movement to prioritize STEM professionals, and I've seen that in my practice. We really see kind of new ways of qualifying our clients for permanent residence through that.
Thank you for that. Okay, let's move on to the heart of our program. And I'd like to open up this discussion and begin by asking you, what are some of the common non-immigrant visa strategies for tech professionals today?
So we can talk about the common visa strategies. I know a couple of people who introduced themselves earlier were talking about, H-1B, H-4, and, starting a new company. There are a few options. H-1B is kind of the most common visa that we see for STEM professionals or tech professionals. It's a visa that we use for many, many different professions. It requires somebody to have at least a bachelor's degree or above in what we call the specialty occupation, so specialized field of knowledge that requires a degree. H-1Bs, we can't get them for people in professions that can be done with many different degrees. It has to be specialized. So the issue with H-1Bs, and I think everybody here probably knows this already, is that it is, unless you work for an academic institution, it is subject to the cap. And the cap has been, so the chances of getting into the cap have been diminishing with each coming year. So for example, the H-1Bs are done through a lottery for private companies, as opposed to academic institutions or companies affiliated with those academic institutions. So for example, this past year, last March, when the latest lottery was run by the government, they received almost 500,000 H-1B submissions, lottery submissions, something like 480,000. The record number. The selection percentage was something like 17 or 18%, so very, very low. And that's kind of where we're stuck. So people who are in STEM fields and who maybe were in the US initially to get a degree and qualified for STEM OPT, that STEM OPT can obviously be extended for a period of time. I generally recommend to apply for the H-1B lottery as many times as you can, just to statistically increase your chances. But H-1Bs are really tough. The other issue that becomes a little difficult with H-1Bs, and that's for entrepreneurs specifically, people who want to have their own company and have an H-1B, or maybe they already had it sponsored by a prior employer, is that it doesn't allow self-employment. So you can't really sponsor yourself for an H-1B. So your company, if you're going to have some partial ownership or full ownership of the company, needs to have either a board of directors or some other way to have that separation, so that it is not, you're not self-sponsoring. The company is a separate entity, of course, legally, but we also have to show that there's a board of directors that's able to hire and fire and has that kind of agency. Another visa that we commonly use for tech professionals, entrepreneurs, people with advanced degrees, especially in STEM, is the O1 visa. O1 is a visa for individuals of extraordinary ability. That's my area of expertise. That's the majority of what I do. It is a really high legal standard. The O1 requires the legal standard is sustained national or international acclaim. So the standard is high. Obviously, not everybody can qualify, but if you do have that level of accomplishment, perhaps publications, speaking engagements, service as a reviewer or editorial service for journals or other entities, that is something that can qualify you for an O1. I often consult clients who talk to me kind of soon after maybe receiving their terminal degree or their graduate degree, and we make a plan for how they can qualify for an O1 visa. Maybe they don't meet the criteria today, but they're sort of on their way. So sometimes I recommend to try to get yourself out there. Some people, especially in tech, tend to be a little shy. They don't want to be in the limelight, but that's what you want. You want to be a star to qualify for an O1 visa. And certainly if we ever want to look at EB1 or NIW further down the road. So you want to take these opportunities, and in fact, you want to kind of get yourself out there and try to get engaged with the community, try to get involved, try to get speaking engagements, publications out there so that you're able to build that CV. And like I said, I often have that conversation with potential clients where I tell them, you're not quite ready yet. Let's think about all these things that you can do. Let's talk in a year, let's talk in 18 months. And that's when we get started on an O1 visa. Again, for those of you who plan to have your own company, an O1 is a better option than an H1B and again, there's no self-sponsorship for an O1. The company has to sponsor, or in certain situations, we even create an agency relationship with a third kind of party that serves as the sponsor. But an O1 is a less regulated visa by the government than the H1B, which requires prevailing wage and posting requirements and things like that. So it's probably a more lenient type of a visa to have if you're an entrepreneur who will have your own company. It is a high legal standard, as I said. So part of qualifying for an O1 visa is having a group of experts support you. So that's also something to think about if your plan is to pursue an O1 visa, or perhaps as a company owner to hire somebody who needs an O1 visa. The beauty of the O1, of course, is that it is not subject to the H1B cap. So we don't have to worry about the lottery. We don't have to worry about the low chance of qualifying or getting in. The O1 visa has to do with the individual's own qualifications. So if they meet the legal standard, they can take up the job offer. So going back to the experts that I was referring to, I generally recommend to my O1 clients to have 7 or 8 reference letters from experts in the field, and saying very nice complimentary things about my client. So we usually work very closely with clients on developing those letters. We'll provide samples or templates and kind of go back and forth on putting the right language in the letters that will serve to qualify them for an O1 visa. One of the reasons why letters are so important is because it's through the letters that we can deliver information to the immigration officer about what our client does, why it's important, why that means that they've reached that high level of expertise in the claim in the field, what their contributions are, and why we care about it. So we have the experts basically testify on behalf of the client in writing. Obviously, it's all done through letter, not in person, providing this information to the immigration officer. And you probably all know the immigration officers, they're not tech professionals, they're not scientists, they don't have advanced degrees. Chances are they're not even required to have a bachelor's degree to have the job of an immigration officer. And we often give them these very complex concepts and big petitions to review, and they also have to adjudicate or understand the law and understand how to administer the law. So we try to make things as streamlined as possible and as simple as possible to understand, and we try to make it easy for them to approve these cases. The other non-immigrant visa that I want to mention, and that doesn't apply to everyone, but it may apply to certain people, and that's called an E2. It's a visa for investors, investors into a US business. An E2 visa is not available to everybody. It is a treaty-based visa. So the United States has to have a treaty with your country of nationality for you to be able to qualify for an E2 visa. And if there is such a treaty, then, and if you plan to invest into a US company, either purchase an existing company or start your own and invest personal funds into that, that's also a really good way to qualify for a non-immigrant visa to be able to work in the US and kind of be your own boss. And that is sort of like a self-sponsored type visa, because you really get to establish your own company and do what you decide to do with that company. So that's the very brief overview of non-immigrant visas, and certainly when we open up for questions, I'm happy to answer questions about any of those.
Okay, following up on that, and thank you. What should tech professionals be aware of when making non-immigrant plans?
Well, so plans is the operative word here. So I always talk about planning. It's really important to think ahead and to plan ahead for anybody who is in the United States on some temporary visa or planning to apply for a green card. And this type of planning involves not just immigration, which is not, sometimes you're dependent on your employer or professional qualifications, legal standards, but it also has to do with your career planning, business planning, planning as an entrepreneur. So all of these concepts have to come together. It's a really complicated plan to establish that meets both career goals, personal goals, and immigration goals. So it is something important to think about. Have a trusted advisor or attorney that you consult with, who will help navigate through these through the various stages of that planning. But in terms of the non-immigrant visa, well, most non-immigrant visas involve a sponsoring employer. Like we just talked about, an H-1B requires an employer, and O-1 requires an employer or perhaps an agent sponsor, but also some type of a third party to sponsor the visa. So career planning and visa planning would really go hand in hand with that. One thing to be aware of is that H-1Bs have a maximum limit. It's a 6-year limit of H-1B status in the US, unless you've started permanent residence at some point during that 6-year period, which will then allow to extend it beyond 6 years. So we often have to deal with situations where clients were not able to be sponsored by an employer for PERM, for example. It does require employer sponsorship, and they reach their 4th year or 5th year, maybe even 6th year, and they're running out of time. So planning is really important in that regard. How are you going to remain in the US beyond that 6-year limit? Sometimes it requires to change an employer, because maybe you're with an employer that's not willing to sponsor, not ready to sponsor, dragging their feet. That happens sometimes. And you may want to be with a more supportive employer that will be willing to do that because the clock is running out. An O-1 visa does not have the maximum limit. O-1s can be extended indefinitely as long as the job exists or whatever the sponsorship opportunity is. So for those who are able to meet the legal standard, which again is not for everyone, that is a fine option to be in the US on a long-term basis without necessarily pursuing permanent residence. E2, same thing. E2s don't have the maximum cutoff. They can be extended as long as necessary, but the business, that's the basis of the E2, the investment entity, has to be operational, has to be working, and so it has to continue. So the business has to be successful for the E2 to continue.
And following up on that question, what about permanent residence planning?
Permanent residence, we did talk about PERM already. That's entirely dependent on the sponsoring employer. And by the way, if you own your own company, you're not able to sponsor yourself for PERM. So those companies where you have ownership or control or significant ownership that results in some level of control is not able to pursue PERM on your behalf. But other options are EB1, somebody I think mentioned a little bit earlier today, the possibility of an EB1. That is the highest legal standard that we have in immigration law. It's extraordinary ability. So it's similar to the O1. The words sound very similar. And in fact, the regulations look very similar, almost identical, but the Immigration Service reviews the EB1 criteria, which is path to permanent residence, at a much higher legal standard. So it is more difficult to qualify for an EB1. In fact, they openly say just because you have an O1 doesn't mean you're going to get an EB1, which I personally disagree with, but that's just that's the climate out there. That's the way that they look at it. So EB1 is one self-sponsored path to permanent residence, and the other one, and that's currently my favorite, and I do want to talk about that a little bit more, is the national interest waiver. National interest waiver, or NIW sometimes we call it, is a path to permanent residence. It's an immigrant visa strategy. It does have the word waiver in it, and sometimes clients who held a J1 visa that had a 2-year home residence requirement attached to it get confused with that. It is not a waiver of the J1 2-year requirement. I know the word waiver appears in both, but national interest waiver is something else. So doesn't have anything to do with the J1. It's a waiver of the PERM requirement, meaning you don't need to have an employer to sponsor you. You can sponsor yourself, and you don't have to have a job offer that's part of the national interest waiver petition. So national interest waiver in the current climate has been viewed quite favorably by the Immigration Service, which is very unusual. Usually everything's difficult, but national interest waivers right now, I think that's that's a kind of more streamlined, favorable strategy, and that is because of the executive, the most recent executive order, and the guidance that I mentioned that came out in 2022 from the White House, DHS, and DOS, all talking about STEM professionals and prioritizing STEM professionals, and specifically referencing the national interest waiver, that is a path for STEM professionals to pursue, and that the government has to kind of be more lenient with that. So in response to that, the Immigration Service, and that's the agency that adjudicates immigration petitions, amended its policy manual. So policy manual is this document that's kind of their cookbook. That's the document that officers reference when they adjudicate petitions. It basically tells them how to do their job, what the legal standards are, what they should look for, what they should consider, what they should disregard. It's available online for any of you who want to take a look at it. It's really interesting reading, and it really gives you an insight into an immigration officer's kind of daily routine, how they look at these cases. So the national interest waiver portion of the policy manual has been amended to add a whole section on how to view STEM professionals. So they talk about prioritizing STEM professionals, what that means if somebody has a PhD in a STEM field, maybe even a master's degree in a STEM field. That's very, very relevant. And the way that they kind of weave that in is that one of the requirements or one of the criteria to qualify for the national interest waiver is that the interest or the field that the person is working on, or the interest of retaining that person in the US, has to be, and that's kind of a term of art, sufficiently urgent. They use the word sufficiently urgent. So how do we meet that sufficiently urgent requirement? Well, the policy manual says that if somebody's working in a STEM field, that's already been presumed to be important to the US national interest, and that satisfies that sufficiently urgent requirement. So That's kind of how they look at it. They specifically identify some things that that they want to see in these NIW petitions. They want to see how the person is helping the U.S. maintain its strategic competitiveness. They want to see letters from U.S. government agencies. I mentioned expert letters. So if you are able to have access to letters from somebody who maybe works for U.S. government agency, or if you have U.S. government funding, or maybe work or have worked in the past for an organization that is funded by by federal agencies, that's really, really helpful. A lot of my clients who are researchers, and sometimes they even work for private organizations, but there is federal funding or some type of government funding that came in. Maybe they're not even listed on the award of the fund, but if they are working on it, if that's part of their job, working on these government-funded projects, that's very, very helpful. For entrepreneurs, again, the policy manual specifically talks about if there's been an incubator or accelerator participation, they find that helpful. Again, grants, any kind of intellectual property. With all of that, what I have found in my practice is that we're able to qualify clients for national interest waivers that maybe when 6 to 12 months ago, I would have said, I don't think you're quite ready yet. Let's give it a little more time. Let's do some of these other things. But today, I think we're able to push the envelope a little bit more with the U.S. Immigration Service because of this particular guidance, and specifically just 2 weeks ago, as we just discussed, the new executive order, which hopefully will open up even more doors. So I'm really pro national interest waiver in today's environment. I think that's a really important path to consider. Now, national interest waiver, the drawback of it is that it is an EB2, employment-based second preference. So all immigrant visas and the employment-based immigration are separated into preferences. So EB1 is employment-based first preference, that's extraordinary ability or outstanding professor researcher. EB2 can be PERM or NIW, so NIW is an EB2, and EB2s currently are backlogged for everybody. Doesn't matter what country you're from, you're going to be backlogged under an EB2. Backlog means there's a wait, there's a queue, there's a wait. Traditionally, the only backlogs we've seen within the EB2 classification were only for individuals who are born in China and India, but today it is applicable to everyone. The hope is that this backlog is gonna resolve in the next several months, but it's wait and see. These backlogs are established by the Department of State, and they're based on complex statistical formulations that they use that nobody really understands. So we get to learn about the backlog for each following month, usually just about this time, mid-month. So we just got the backlogs for December. So in mid-November, we know what's going to happen in December, and they really did not move much. So that is definitely a drawback of pursuing an NIW, but it is a way to get yourself into the queue and perhaps work on evidence to eventually qualify for an EB1 to meet that really, really high legal standard.
Okay, thank you. I know you've already sort of touched on some of the elements of my next question, but because it is a frequent question, if somebody has a PhD, is that enough to qualify for an O1, an EB1, or a national interest waiver?
Well, it's definitely helpful because to attain a PhD, most people have to publish, they have to research, they have to do a lot of the things that we usually want to see in an O1 case, EB1 case, and NIW case. But it's, of course, it's not a guarantee, and everybody is different, every case is different, and we evaluate everybody's credentials in their own right, kind of on their own, to see what the best strategy would be. So no, just because you have an EB1, just because you have a PhD, it doesn't mean it's a guaranteed O1 or any of these other categories. But it's certainly, most people are certainly at least on their way to getting there.
Okay. And one last question before we open things up for Q&A. In today's environment, what does it take to win?
Well, I think it's the things that we just talked about. It's being a good planner, thinking about the full trajectory of your immigration case in advance, making sure that you have a supportive employer if you're going to be sponsored by an employer, or making a good plan for enhancing your qualifications if your ultimate goal is to pursue an O1 or an NIW, perhaps. Maybe if you are starting your own company, how is that going to go in view of the immigration planning? So I think I'm just going to probably finish this with the reiteration of planning. That's really important. And I think having trusted advisors, being advised by somebody that you trust, that is able to kind of guide you in the right way. So I think I'll finish with that, and I know we have some questions, so I'm happy to answer any questions.
The floor is yours.
Hi, hello. Yeah, first of all, thanks for organizing this. Those have all very valuable information. So I know it's recorded, but I guess I'll talk about a bit of my situation, and there's my question. So I come from China. I have a PhD from UIUC, so I already got my EB1 sponsored by my current company. And actually, I already got approved I-140, and I'm just waiting on. So I already also submit my 485 form. I'm just waiting on the priority date because for EB1 it has been stuck there for a long time. Starting from this February, I think stuck there for some time now. My priority date is actually just 2 months from that current date, but it has been moving a lot. So that's my conundrum, I guess. So and now my situation is that I'm now would like to start an AI startup. I'm getting my first customer, so that's why I just incorporate the company. So I guess I have 2 questions. One is there any way to expedite the approval process for the 485 form? And the second question is that I think you touched on this a little bit, like and I talked to some investors I know. So forming a board so that basically I can be fired, right? So it's a way to transfer my current H1B and also transfer my EB1 sponsorship to my company, right? So but actually, I want to see is there any risk involving in this, because my concern is that I'm so close to the priority date. Is maybe better just to wait a few months, or what's your take on I guess.
Yeah.
I know it's
so,
hard to predict. Yeah.
When was your I-45 filed?
It's March 2022.
March of 2022.
Yeah. So I know the priority date is currently February 15, 2022. So it's just
I-45 has been pending for 1.5 years.
Yeah. I'm sorry. No.
The I-45 has been pending
for I think so for half a year. I think I submit that.
So March 2023.
No. So that's when I filed for I-140. So that's
not filed. Have you filed the I-45 yet?
Yes, that's in October last year.
So October, a month ago, or October 2022?
October 2022.
Okay, so since your I-45 has been pending for more than 6 months, more than 180
Yeah.
days,
Yeah.
you can port. There's a concept called portability. You can port to another employer as long as you
Okay.
continue working in the same
Yeah.
or similar occupation.
Yeah.
So that includes your own company. So if you're your own startup, you're going to work there in the same or similar occupation, and
Yeah.
obviously I don't know I haven't reviewed your credentials. I haven't reviewed any documents, so I can't give, none of this is legal advice. This is all general stuff.
Yeah.
But
So,
if you are able to demonstrate to the government that your new job is in the same or similar occupation as the initial job that was subject to the EB-1 approval, then you're able to move, and you don't have to file a new EB-1. You'll basically just get a green card based on that prior EB-1. Same thing would happen if you were terminated by your employer. So you would have to find another job, or again, you've got your own company coming, where you would port, basically. But that portability is an argument. It's not guaranteed. So
yeah.
it is something that, would need to be kind of presented by an attorney to the government and to demonstrate that you meet the criteria. The other thing that I would suggest is I would suggest for you to not move your H-1B to the new company, but see if you can qualify for an O-1. I'm assuming if you got an EB-1 approved, you should be able to meet the O-1 standard. And I think it's a lot easier to get an O-1 for a startup, especially if you have an ownership interest in that, than an H-1B.
May I ask a quick follow-up? Just how long would be the portability process look like?
How long would the process be for the O-1?
No, for the EB-1 portability process.
Well, it's a filing that gets made, that gets filed with the USCIS, and basically, ultimately, USCIS would, assuming success, would just approve your green card when your priority date becomes current. So if it's not current yet, obviously you're just kind of sitting there in the waiting line, and then when your priority date becomes current, which you're saying you're a few months away, then they will kind of take your case off the shelf, and then it might take another 6 months for them to finish it up. But so it's not instant, but if you in the meantime move to another employer, that portability filing is going to have to be made. Or the immigration service may issue a request for evidence saying, well, we see you no longer work for your employer, or do you still work for your employer? Sometimes they know or don't know, and that's the time to make the portability argument.
Oh, I see. Understood. Okay. Yeah. Thank you. Yeah.
Okay. Any other questions?
Hey, yeah, hi, Rita. Thanks for the information. Very helpful indeed. So as I had mentioned earlier, both I and my husband, we've been on H-1B for, I don't even know, more than a decade now. We're both born in India, so we're in this never-ending loop of waiting. And so his priority date is an EB-2 category in 2015. And it keeps moving back and forth. So that's why I'm planning to go on H4 and get my EAD by the time so that I can start my company. So a couple of questions for you on that front is that we have filed with the USCIS, the whole H4 transfer. And in parallel, like by the time that comes, can I also think of starting like is it even worth starting an O1, or because I'm planning to apply for an accelerator and start a company in the AI space? So is it even worth it? Because ultimately we'll still be in EB2, even with national interest waiver and whatnot. So irrespective, you will still fall into this EB2 bucket. So the ultimate goal of getting a green card won't be accelerated as much. So should I just stay put
Right. Yeah, if you are able to get your husband is maintaining his H-1B status and you're going to get an H-4 EAD, I don't see the reason for you to pursue an O-1. O-1 is, complicated, never guaranteed, expensive, all of these things. So you have a fine way to be able to work on your EAD for any company that you wish, including your own company. So I don't know that it's worth your while to pursue an O-1. And you're
Mhm.
right, unless you are also able to qualify for an EB1, and obviously I haven't reviewed your CV, so I don't know.
Mhm.
But unless you can meet the EB1 criteria, either you or your husband, then
Mhm.
you are still stuck in retrogression. And I think right now, with the priority date of 2015, I think right now they're looking at 2012 or something like that. So
Yeah.
that may change. It may not necessarily be another 3 years. Maybe it'll be a couple of years, maybe less than 3. But yes, you are still going to be waiting for them.
Got it. So just like for the EB1 thing, we just have to like again talk with you later offline, actually review everything and then make sure that if like going through like something like a YC or some accelerator kind of helps that case, maybe it may be worth it.
Perhaps. So the
Okay.
one option that would be definitely worth your while is if your husband can qualify for an EB1, because if he can meet the EB1 standard, then he gets to keep the priority date. So then, you can apply for adjustment immediately because, EB1
Got
is
it.
up.
Yeah, my priority date is 2020, Jan 2020 or something. And I'm also Indian, so
Right.
yeah.
So then if both of you have priority dates, then it's a matter of kind of reviewing your CVs and see who has the option of applying for an
Okay.
EB. Again, it's a high legal standard, so it's a hard one.
Exactly. Yep. Totally
meet.
understand.
But if one of you is able to do it, then yes, I think that's a fine way. That's a fine strategy.
Gotcha. Okay, yeah, definitely we'll touch base on that because while I do have like 3 STEM degrees, I don't do publication and stuff. So then it becomes like, what's worth it, what's not. But yeah, we can take this offline and I can connect with you
Yeah.
later.
Yeah.
Okay.
Here's a question that we received offline through the Xoogler community. I have been with my partner for over 12 years and we have 2 children together. Would we have to be married for her to qualify for a partner visa and be able to work in the US?
Yes, the answer is definitely yes. The US does not recognize common law marriage, so they would have to be legally married in any country. It doesn't have to be in the US, but they would need a government issued marriage certificate.
Okay.
Thanks, Rita. I was actually the one that submitted that, so I appreciate the answer there.
Yeah, absolutely.
Are there any other questions before we wrap things up?
Rita, I did have a follow-up question. So again, super new to this. I'm currently an Australian citizen and a UK citizen as well. I'm currently based in Sydney and looking to emigrate to the US. I was just wondering, with regards to the L1 visa, and apologies if this is a really basic question, but is the L1 visa just for transferring within a company, or would it be also for a new job at a new company in the US as well?
L1 visa is an intra-company transferee visa. So it is only for transferring within a multinational company. So the company has to have a branch outside the US where you've worked for at least a year, and they would have to be transferring you into a related company in the US. So that is the only way. You can't transfer to a whole other company. But as an Australian citizen, you actually have the option of the E3 visa, which is only for Australians. It's a treaty visa, and it's very similar to the H-1B. You have to have a degree in a specialty occupation in a specialized field, and the job has to require that degree, but you're not subject to the lottery, the H-1B lottery that we talked about. So it's a really fine way to be able to work in the US, but you do have to have an employer that would sponsor you.
Amazing. Quick double click into that. So when you mentioned that the degree has to be related to the role, I have a degree in environmental economics. I'm currently working in the tech space. Obviously not quite related, however, I mean, some of the skills are ported over, but does it have to be completely related to the role that you're looking at in the US? Or does it just have to be a bachelor's?
It has to be related, but they're obviously the answer is really going to depend on what the job is, who the employer is, what they want you to do, what your experience is. I'm assuming you're going to get a job in a field that you could bring something to the table, they're going to hire you because you've got the skills. So sometimes what we're able to do is maybe your actual degree that you received from the university is in one field, and because you've had work experience in a related field, we can kind of combine that together and get an evaluation for the field that we want for the H-1B or for the E-3. So these are all kind of strategy questions that can be answered once you have a specific job offer.
Fantastic. Appreciate your input. Thanks, Rita.
Okay. Is there anything else? Well, if not, Rita, thank you very much for your perspective and counsel. And we want to thank everybody for joining us. For any of you watching, if you have any additional questions for Rita, feel free to reach out through her LinkedIn. Thank you, and hopefully we'll talk soon.
Thank you, everybody.